get started. We're still awaiting our third speaker, but I'm hoping she'll join us very soon. My name is Ellen Layton. I'm here at the Schar School. I'm the director of the International Security Program, and I'm a big fan of the work of Louise Shelley, so I was really delighted to be able to contribute in some modest way to what's really been a very, very interesting day. I think this panel will put some of these issues in a bigger box, if you will, and we'll try to think about the problems that are manifested in abuse of red notices at Interpol as part of a larger problem of how the interstate system works when there are shared concerns about crime, criminal activity, terrorism, et cetera. And we have speakers that bring enormous expertise from several different institutional perspectives. So I hope that you're all ready to sort of put Interpol in perspective, and we're going to look at some other institutions in which information sharing, cooperation, or perhaps failure to cooperate on questions of criminality and extradition of nationals that are accused of crimes, et cetera, take place. So first we're going to turn to Michael Chertoff, who's currently the executive chairman and co-founder of the Chertoff Group, an advisory services firm that has become a very important player in Washington. From 2005 to 2009, he was the Secretary of the Department of Homeland Security, and earlier in his career served as a federal judge and as head of the Department of Justice's Criminal Division. To my immediate right is, and to his right is Ben Emerson, who is an international lawyer specializing in national security, counterterrorism, and international human rights and humanitarian law. He has been an advisor to the special courts, the tribunals on Cambodia, Rwanda, and the former Yugoslavia. He teaches at Oxford and represents a number of clients in cases that are very similar or familiar to what we've been discussing all day. So I thought as a kind of opening round, I would invite these two very distinguished gentlemen to just bring some other institutional perspectives to bear on drawing on their own careers and institutions that they've worked in of how problems of international law enforcement have played out and what their own interactions have been. One of the themes that we want to pick up on that I think Ben Wittes in the previous panel said very well is that really the crux of the matter is how countries that have a rule of law culture and tradition, how they interact with countries that do not. And that we pretend that all sovereign states are equal and it's a fair system and that we're interacting on the basis of some common assumptions about the importance of law. But in truth, we are, particularly in the cases of Russia and some other cases we looked at today, we're deeply aware of how these multilateral institutions can be misused by countries that really have a very, very different concept of the law as a prerogative of executive authority rather than a rule of law culture that I think is familiar to many of us. So I wonder if I could invite Secretary Chertoff to reflect on your own career and how these themes resonate with you.
Well, to be honest, when I was at the Department of Justice, we weren't really dealing with the Russians very much. It was obviously right after 9/11. We were fully immersed in dealing with counterterrorism issues. We also had Enron and a number of financial scandals. When I was at DHS, we did interact with the Russians. Groups of the interior ministers would periodically meet, the ministers from Europe as well as the Russian interior minister or the head of the FSB. Who was a fellow by the name of Patrushev, who's now the National Security Advisor. And the idea was, again, to see if there was a means of cooperation, particularly on counterterrorism issues. That was an area where the Russians had a keen interest, although I think there's some reason to wonder whether some of the most notorious incidents that occurred in that decade were actually instigated by the government in order to create an air of crisis. But at least there was some interest in cooperating. And I remember we were over in Moscow. But I don't think that we I would say trust would be the wrong word. I would say we were prepared to listen and talk and see if there were some areas of mutual interest, but we didn't kid ourselves about the nature of the relationship or whether the fundamental interests diverged. Now that, of course, is quite a while back, and I think matters have deteriorated, to be honest, since then. The other experience I've had in dealing with the Russians is in the cybersecurity area. And since I've left government, I've dealt both with it as a security advisor and consultant. I've also had the opportunity to engage in a little bit of what they sometimes call track 1.5 diplomacy, where you send people over who are not government officials to meet with their counterparts to get some sense of whether there are any areas that are fertile for discussion and agreement. And I was over in Moscow a couple years ago with that, and then we had a subsequent meeting in Brussels. And there again, I think as long as you're suitably skeptical and aware of what the fundamental differences are, there may be some areas where you can get cooperation, but you need to be, kind of tough-minded about what those really are and how, as Reagan used to say, you want to verify. I will say one of the challenges with the Russians is the line that we observe between private activity and government activity in the West is not observed. And there's a general sense, and it's basically based on my experience as well, that the Russians will use, for example, criminal organizations to carry out operations. And the deal they'll make is, as long as you can commit crimes and do what you want, as long as it's outside the country, but you have to make yourself available to us when we want you to hack into something or steal something. So that suggests that the way the judicial system is going to work in Russia as it relates to criminal activity online is going to be skewed by an overarching objective to make sure that the individuals who are carrying out cybercrime are making themselves available to the state.
Mm-hmm. Your discussion of the interior ministers, was that in a kind of, what were the parameters of that? Any country, or was it the select group of countries?
It's 8 countries. There were 7, I think 7 European countries and the Russians. And they had annual meetings we had in various parts of Europe to discuss largely counterterrorism issues at that point in time.
Thank you. And welcome, Suzanne.
Thank you.
I'll get to you in a minute, but what we're asking each of the speakers in the first round is to bring your different institutional perspectives, not necessarily exclusively to Interpol, but to other kinds of experiences with international cooperation on issues of criminality, counterterrorism, where the U.S. is interacting with non-democratic states, of what are some of the problems and challenges of those kinds of relationships. Mr. Emerson?
I'm going to suggest a slightly different calibration to the discussion from that which I sort of picked up in the last session, which is essentially that the challenge is to find ways in which a rule of law system can adequately and in a granular way examine individual instances and identify particular cases of manipulation or abuse. My experience is rather different because it comes from a number of contexts in which I have found myself, and I declare an interest in this, in an oppositional legal position in one way or another to the Russian Federation. So I represented the family of Alexander Litvinenko, who was the former Russian Secret Service officer who was murdered in London in 2006 using polonium as an instrument of murder. And in the public inquiry, which took 10 years or so to get off the ground, that followed on from that. And during the course of that, I had a great deal of exposure to the way in which the Russian state engages with international legal structures. Because in reality, everything that could possibly be done to obstruct and frustrate justice by the Russian Federation's central authorities, including critically, the ICRF, the Investigative Committee of the Russian Federation, was done at every possible stage, from non-disclosure to non-participation to the provision of false information, a deliberate and concerted state-sponsored attempt to disrupt, manipulate and distort an entirely open judicial process in the United Kingdom, the object of which was to identify two individuals who conclusively were proven to have committed the murder of Alexander Litvinenko. And pretty much the day after the evidence had been elicited, which was the absolute smoking gun in the case, with traces of polonium found in the U-bend in the bedroom sink in the hotel in which the two assassins had been alone the night before the murder. So there really was no other possible explanation. The following day, Vladimir Putin pinned a Medal of Honor for services to the motherland onto the chest of Andrei Lugovoy, the principal murderer. So there was, an absolute flouting of any attempt to respect judicial systems or the rule of law. Since then, I found myself representing the government of Georgia in its interstate litigation against Russia in the European Court of Human Rights for the invasion of South Ossetia and Abkhazia in 2008, and now the government of Ukraine in its interstate litigation in Strasbourg against Russia for the annexation of Crimea and the sponsorship of the war in eastern Ukraine. And in all of these situations, the pattern has been the same. Now, bear in mind, these are not individual isolated prosecutions against particular people involved in trading activities of the sort that some people have been discussing here today. They are cases which go to the very heart of the interests of the Russian state. But the behaviour has been that of a shoddy, low-level mafioso criminal being charged with running a protection racket and willing to cover up at every possible stage in the cheapest, most obvious, and easily exposed way, as if the principle of plausible deniability has given way to a stance of implausible deniability. It doesn't really matter whether anybody else believes the explanations or not. Indeed, one wonders whether sometimes it's not deliberately intended that nobody should believe the explanation. In other words, it's sticking two fingers, or as you would have it, one finger over here, up at the entire democratic system of rule of law enforcement. It's basically saying, look, we can do whatever you need us to do. We can produce whatever documents you need us to produce. We can tell as many lies as you need us to tell. I've cross-examined a senior Russian general at the European Court of Human Rights and put in front of him photographs with serial numbers from rockets sent in by the Russian forces, an Iskander missile, into a civilian area in Grozny, and asked him to explain the photographs, to which the answer was, they're made of plywood, they're fake, they're not real, no one died. It's just a completely shameless denials of responsibility, which no one believes. Now, the question is, are our institutions robust enough to get underneath that problem? And I heard several of the speakers earlier on today saying, well, of course, there's no prospect of de-recognizing Russia or suspending Russia from the system. I personally am not convinced that that's correct. I think when you have a state which it can be shown repeatedly to have violated the fundamental principles of institutions like Interpol, there has to come a point at which those institutions intervene to protect themselves. One of the problems, and Ben Whittis touched on it earlier on, is that all of these international institutions are built upon the mythical principle of comity. In other words, they don't have built within them the safeguards and checks and balances that are necessary to protect against, and I have no problem using the word abuse, against deliberate abuse by a state where organized crime and government are so indistinguishable that they amount to one and the same thing. You're not doing business with the state in any conventional sense. You're doing business with an organized criminal enterprise which has the trappings of a state. Now, in those circumstances, what is the right solution? Is it as some of the speakers have urged, to dig a bit deeper. I mean, my experience of challenging via Interpol Russian abusive applications is that the organization is simply still not fit for purpose. It doesn't have the tools at its disposal to expose the political abuse of its own processes. Its decisions are superficial, they're arbitrary, there's no real analysis. I mean, unless somebody is charged with an overtly political offense, like being a member of a political party or organizing a demonstration, or unless they happen to be a politician, the committee is extremely reluctant to recognize the inherently political nature of the way in which Russia uses these international institutions. So I've seen it in pretty much every institution, judicial or legal, that I've had to deal with. So at the European Court of Human Rights, straightforward lies, manipulation of a kind that you just would not associate with a state. In the assassination cases, constant howling about how the UK or other countries won't extradite people like Bill Browder to Russia, but absolute refusal to extradite the proven murderers of Alexander Litvinenko and others to the states where they committed their crimes. And Interpol is just the same. I personally don't think this is a relationship which is capable of being tinkered with or remedied by minor change. There are three ways in which it can be attacked. Number one, the Interpol rules themselves require the Commission to take account of the identity of the National Criminal Bureau which is making the request. When you have a bureau, as you do with the Russian Federation, that has repeatedly abused the system, then that needs to be a presumption in any case where there is inadequate evidence against an individual that there is a motivation for their prosecution other than one which is the administration of justice in an impartial way. The second option, and I think it's a very real one, is for Interpol to consider its powers to suspend for a period of time the workings and access of the organization to the Russian Federation because of the number of instances that there have been. I mean, when one looks at the pattern, this is not me speaking, Interpol itself and national courts in many rule of law jurisdictions have refused to give effect to requests for international assistance, warrants, evidence, extradition, because of political abuse by the Russian Federation in the particular case. Well, if that is a pattern of behavior, and if we see an inexorable rise as we have done in Russian applications, then we have a very serious problem that needs very seriously to be addressed. And then the third question, and it's one which was raised last week during the process in Dubai for the election of the new president, is if Interpol really can't protect itself against the abuse of its systems by Russia, and when we talk about other rule of law, other countries that are not rule of law countries, we are by and large talking about countries from the former Soviet Union who have adopted the same pattern of abuse. If that is the position, and Interpol cannot show itself capable of resisting this, then the question arises whether Interpol in its current form continues to be the right vehicle for international law enforcement cooperation between rule of law states. And I think those issues are very, very real. And the fact that in the way the system operates at the moment, there are individual defendants who are struggling to persuade Interpol that the prosecution against them, often buried under many, many layers of complexity in an alleged fraud that's been manufactured by the Russian authorities, are trying to persuade Interpol to look at their case objectively and to find that it's outside the Interpol constitution or in violation of Article 3. In reality, at the very least, the burden of proof ought to be reversed in those cases, because otherwise they are bearing the burden those individuals are bearing the burden of trying to protect our international cooperation institutions. I mean, if we all agree that there needs to be, I think probably do all agree, there needs to be an effective and a just system of international law enforcement cooperation of that kind, then it shouldn't be up to individuals who are being hounded by the Russian authorities to try and protect that system. It should be up to those of us who subscribe to the rule of law in democratic states to stand up and make sure our institutions are still fit for purpose. That's my take on it.
Thank you. I'd like to now introduce Suzanne Spalding, who was Undersecretary of DHS for Cybersecurity and Critical Infrastructure Protection. She spent some time on the Hill, both on the House and Senate Intelligence Committees, currently an advisor on Homeland Security at CSIS, and also was the counsel, the legal advisor to the CIA's Nonproliferation Center for a number of years. So Suzanne, I don't know if what you've heard so far, if you can direct some of your own, draw on your own past experience and contribute to the debates.
Great, thank you, Ellen. I'm glad to be here. It's sorry to have been a little bit late here, but a fascinating conversation. So I'm going to accept your invitation to broaden the discussion a little bit, provide a broader context for this, and respond to your suggestion that I, weave in some of the experiences that I've had in dealing with non-democratic states. So for me, the biggest contrast, of course, was the relationships that we had, the discussions, negotiations with the Chinese, and what we experienced with the Russians. And I will circle back to the word that you used, which I think is so apt, which is shameless, when talking about the Russians, and quite the opposite, frankly, when talking about the Chinese, at least in the time period in which we were having these conversations. So this was in the context, my role at DHS was I was responsible for cybersecurity and critical infrastructure protection. And so we, post-OPM breach and lots of other cyber activity that caused grave concern, entered into finally some discussions with the Chinese. And it came about as a result of articles in the Washington Post about the fact that the administration was seriously considering imposing sanctions on China for malicious cyber activity, for intellectual property theft and other malicious cyber activity. And this was in the weeks leading up to President Xi's first official visit to Washington, D.C., where they were planning the grand welcome, the ceremony on the White House lawn, et cetera. And President Xi did not want anything to mar that show that he believed, I think, demonstrated his arrival on the world stage as an equal partner, which has always been a key talking point for China. And so they sent a plane load of very senior officials on an emergency basis to come and try to see what they could do to avoid those sanctions being imposed. Several days of negotiations, the final day of which was really basically an all-nighter, in which we finally did get an agreement from China for the first time where they said they agreed that a country should not steal sensitive business information from another country for the purpose of providing a commercial advantage to one of their own companies. And that was a pretty surprising agreement on their part, because they had always maintained that was no different than what we claimed the right to do, which was traditional national security espionage. To them, the line that we draw between industrial espionage and national security espionage was non-existent. And so they had always maintained that they ought to be able to continue to do this. And they finally had agreed, and it was an agreement that President Xi then signed personally with President Obama. And those on the outside who follow Chinese malicious cyber activity, the FireEyes and CrowdStrikes of the world, said that following that agreement, a dramatic decline in cyber activity by the Chinese, at least that they were able to detect. So that's one example. I think, bottom line with all of these non-democratic states is you got to figure out what it is that motivates them. What motivates them, all of them, Russia, China, North Korea, Iran, is regime preservation. So then it's about what do they think is necessary for regime preservation. For China, it is grow the economy and control information that reaches their population. Growing the economy requires, in China's view, that they have a certain reputation on the world stage that allows them to go and exert their influence and gain economic advantage around the world. So that leverage worked with China. Switching gears now to Russia and where we had one effort at discussions, quiet discussions with Russia around cybersecurity cooperation, were there grounds for cooperation on cybersecurity, that frankly didn't go anywhere. But where we did see, of course, Russia meddling in the election in 2016. And again, I think looking at what Putin feels is essential for his regime preservation, there, like China, is a need to sort of control the population. But Putin has no great wall that China has built. China has effectively built the technology to pretty effectively control information that gets to the vast, overwhelming majority of its population. Putin has no hope of controlling the information that reaches his population from the standpoint of preventing information from coming through. So what Putin has done instead is to overwhelm the information sphere within Russia with disinformation and create a feeling of there is no objective truth, right? To get his own population to shrug their shoulders at institutional corruption, at lies coming from government officials, from institutions, at misinformation. There is a sort of an attitude of course, everyone is corrupt, everyone lies, and they shrug their shoulders. So that has worked pretty well in Russia. He knows he has no strong economy that he can use to compete effectively using economic influence around the world. So what Putin has adopted in terms of that, trying to control his population and compete around the world is a scorched earth philosophy. That is to tear everyone down. He can't rise to the level of the United States or even to China, which does try to sell its brand of communism, of capitalism with communist tendencies, or communism with capitalist tendencies. Putin instead tries to pull everyone down. So what Putin's approach is to say to his own population, to our population, and that's what I'm going to focus on, and to populations around the world where we compete for influence, is, okay, so you believe we're corrupt. Everyone is corrupt. You're corrupt. You're corrupt. All these institutions are corrupt. There's no shining city on a hill. And what we saw in the run-up to the elections in 2016 was, as much as anything, an attempt to undermine the credibility of the outcome of the election. Now, there are often, in addition to the strategic goal of simply undermining public trust and confidence in democratic institutions and in the concept of democracy, rule of law, and the idea of truth, is a tactical objective, right? And in this case, the intelligence community determined that it was to weaken Hillary Clinton, and I think a tactical objective in undermining the legitimacy of the outcome of that election was so that when the expected result that she got elected happened, she would be in a weaker position. As they saw Trump gaining steam, they started, in fact, then assertively trying to assist Trump. But the objective was really to undermine public confidence in this fundamental democratic institution. And what I have seen since leaving DHS, I started thinking, if they want to undermine democracy, where else would they go? They will go after the justice system. So not only using the justice system in ways that you've discussed today to achieve their corrupt ends, but actually really undermining public confidence in the idea of an impartial and independent judiciary altogether. And we have gathered over the last year a growing body of evidence that this is a very specific campaign, doing what Putin does, which is to take advantage of weaknesses and divisions of our own making. So the idea that judges are just politicians who wear robes. We see the ways in which Russia, from Putin's statements to Lavrov's statements to RT and Sputnik to social media, reinforce that skepticism and create that, again, that idea that the courts are all biased, there's no such thing as independent and impartial, they're all corrupt. So I will close with the opening of a weekly program on RT called America's Lawyer. You may have seen their ads in DC on the bus stations. Is this American enough for you? Said the ads. It's hosted by Pensacola trial attorney Mike Papantonio. And the unrelenting theme of this weekly broadcast is that America's justice system is corrupt and broken. It has been taken over by corrupt politicians and big business to achieve their own corrupt ends. That's what Putin wants us to believe and is pushing that narrative every day.
Well, on that dramatic note, let me try to draw from all three of these very compelling presentations let's sort of switch on, what's fixable. Is there anything here that I think Ben Emerson has said, let's be careful and make sure that we don't lose the integrity of our own institutions. We can't fundamentally change theirs, but we can. I think your example of 8 countries that get together, it reminds me that we disinvited Russia from being part of the G8. So whether we are, so there's different layers. There's within nation states, what do we do to protect and defend ourselves? At the minilateral level, we can be more selective about who's in the club and who's outside the club. But that doesn't solve our problem at the global level. And whether there's an erosion of legitimacy of the true multilateral level where all nation states are allowed to participate. So people fret on the anniversaries of the UN, has the UN lost its effectiveness, et cetera. I think we've heard some very disturbing, worries about whether Interpol is fit for purpose, as it was said. So I would just like to invite all of you, each of you, to reflect on whether it's Interpol or other multilateral fora in which you've engaged. Are we facing a world where what we used to call the international liberal order was really always the Western liberal order, and that there are alternative, should we sort of circle the wagons and say, well, we're going to stay with like-minded countries because we know who to trust and we have some shared values and we can work our problems at that level of trust. But what do we do about the permanence of the problem that these non-democratic countries are becoming more powerful? They have a lot of influence in the international system, and maybe China will be a more nuanced case than Russia. Maybe it will continue to be a somewhat more nuanced case. But whether you see us facing a bifurcated international system, whether you think that sticking with like-minded countries is at least a minimally acceptable solution or approach to take, or do you have other ideas of what we should be doing so that some level of international cooperation can continue even with countries that are working so hard to undermine it? Tough question, but any of you would like to jump in on that? Yeah.
I mean, I don't doubt for a moment that there are some very bad people being chased by Russia around the world using Interpol. The problem is that it's impossible to tell who's a bad person being chased by Russia for a good reason and who is a good person being chased by Russia for a bad reason, because the evidence that is manufactured against both groups will appear very much the same, and the institutions that we have are not built in order to conduct that depth of scrutiny that is required. They were built on the assumption that they were that you mentioned a moment ago, that they were cooperation between rule of law-based liberal democracies. I mean, I can remember. I think the problem dates back to Perestroika and Glasnost, to be frank. I mean, I think in 1993, Russia adopted its shiny new constitution. And I can remember being sent at the time by the Council of Europe as part of a series of missions that were being sent to Russia under its new democratic, apparently human rights compliant constitution, to try to prepare the country and the Council of Europe for it to accede as a member of the Council of Europe. And that was vital because becoming a member of the Council of Europe meant that Russia would be subject to the jurisdiction of the European Court of Human Rights. So it would be a part of the European constitutional order. But at a stroke, it doubled the size, both geographically and in terms of per capita membership of the jurisdiction and funding. And so there were many voices at the time who were saying it is insane to allow Russia to become part of the Council of Europe because it's a minimum requirement, obviously, that the state concerned when wanting to join the Council of Europe should be adhering to the rule of law standards in the European Convention. Otherwise, you're automatically bolting on an incompatible legal system. And then there were those who said, no, but by allowing them in, we will gradually spread eastwards the doctrines of democracy and the rule of law on which the Council of Europe is based. And that's the moment at which the battle was lost. Because the reason we are where we are today is because those in Russia watched the West celebrate the fall of the Berlin Wall and triumphantly congratulate itself on the success of democracy and capitalism over communism and authoritarianism. And in that process, allowed all of our potential guards to fall. And that's why globalization, it's why global marketing, it's why global communications and social media, it's why influence operations and so forth have become possible, because democratic states did not defend themselves or their systems because they thought they'd won. In fact, that is not the case, because very shortly afterwards we saw the rise of Putin. So 96, Russia joins the Council of Europe, and whatever it was, almost immediately Vladimir Putin is prime minister. And in the time since then, we have seen a state that had a moment of optimism slide into not just kleptocracy, but murder and a mafia-led government. Now, who goes into business with a mafia-led entity and expects to be able to trust what they tell them? I mean, I find it, in a sense, naive when organizations who are looking to see Interpol work better talk about fine-tuning the system. Because the problem here is not a problem that can be resolved by fine-tuning. It is so fundamental that something fairly significant and fairly radical is going to need to happen in terms of our ability and willingness to cooperate with a fundamentalist. It's not about a rule of law. I mean, the language that was being used earlier on is all about how do you match a rule of law with a non-rule of law state. The implication being that maybe their systems aren't quite good enough to pick up every irregularity. That's way off beam. The analogy is inviting a policeman and a criminal to go into business together and run a law enforcement operation. And I mean, in a sense, I don't think there is a very simple solution to that. But I do think that people need to start to up the rhetoric a little bit. And to recalibrate the response from one that says, this is a terribly difficult problem, we all need to buckle down and concentrate and look out for the
Is there a mechanism
abuses.
in the Council of Europe to dismiss a member?
So what's going to happen in the Council of Europe is very interesting. Let me give you some institutional comparisons. So, International Criminal Court has Russia is a signatory to the Rome Statute, but the moment the prosecutor and the court announced an investigation of war crimes committed in the Russian invasion of Georgia and South Ossetia, they de-signed and refused to cooperate with the ICC. So they've pulled out of the ICC system because they're under investigation. In the European Court of Human Rights, we're at a bit of a pivotal moment, because in May, we argued for Georgia the case of the connection with the Russian invasion of South Ossetia, basically arguing Russia is responsible for the war crimes that were committed by the proxy forces of the South Ossetian regime and by its own forces. And we know, because it's open, that Russia has lobbied both in public but also in private judges of the court with a view to essentially persuading them that if they find against Russia, and the evidence is, as you would expect, all one way, if they find against Russia, Russia will pull out. That's the threat. So, I mean, we know what the consequences of that are going to be, because the mistake was made in the first place to let Russia into the Council of Europe. If Russia pulls out of the court system as a result of this judgment, if it goes against it, it will halve the court's budget, halve the court's staff, halve its jurisdiction, and essentially threaten the continued existence of the European human rights protection mechanisms. So the court itself is in a caught on the horns of a very real dilemma as we sit here today, because if they find against Russia, it proposes a threat to the institution's ability to continue. If they find for Russia, it poses a fatal threat to the institution's credibility in continuing. And that maybe explains why in November there's no sign of a judgment yet.
Thank you.
So, I would say a couple of interesting observations were made. One is, I do think that in the early 90s, there was a belief in what we can, kind of generally call Western liberal democracy, that when people in other parts of the world were exposed to Western liberal democracy and economic liberalization, inevitably the arc of progress would move in favor of Western liberal democracy. Turns out not only is that untrue, but it may actually be the opposite. Authoritarianism has actually gravitated into what were formerly liberal democracies. And it's not by a coup or force of arms, but it is by the democratic process sometimes embracing authoritarian issues. And I could go to Venezuela, I can go to Turkey, as well as what we see in certain parts of Central Europe. So there was perhaps an unduly optimistic and even Pollyannish view that in an open competition, the liberal democracy and the rule of law wins. So that's one issue. The second issue is, given that fact, those countries that still are basically liberal democracies need to decide how they address the rest of the world. Now, I'm not suggesting you disengage, but I do think you have to be prepared to make value judgments and act on them. And I think too often in the West we get twisted around a kind of a need for a superficial objectivity, where we don't feel we can make a judgment about another system, so we therefore have to kind of simply accept the way things are. But the reality is, for example, it may well be that a country that interposes the Interpol, that abuses the Interpol process a certain number of times ought to be told you're suspended. Now, obviously there are some righteous cases that will not be pursued, but without that, you're going to encourage more bad behavior. Another classic example of encouraging bad behavior was when the Russians began to use and encourage the use of chemical weapons in Syria, which is a clear violation of treaty and international law. There was threatening about a red line, and the red line suddenly disappeared into a faint pink. And I will tell you, in my traveling around and talking to individuals, senior officials in other countries, that was again and again was brought up to me as, how can we have confidence in these institutions and in America when you don't enforce the rules? Now, it's tough to enforce the rules, although we did more recently take steps after chemical weapons were used and didn't cause the earth to fall. But I do think you have to be tough-minded, and at some point you have to say, keeping the simulation of an international agreement or institution isn't worth it if you hollow it out. And you're better off simply saying you're suspended. We'll still, on an ad hoc basis, we're always willing to talk, but we're not going to kid ourselves to believe you are on equal footing with liberal democracies.
Well, and I see, obviously, the United States, not just this administration, but in previous times, we have walked away from international organizations because we thought they had been compromised or corrupted by the, giving the head of the Human Rights Commission at the UN to Libya, for example, or something like that. Suzanne, both you and I have been in the intelligence community, and I do think, Intel as one channel of international cooperation has some advantages that it can really be very controlling of who's in the room. So that you have your sort of trusted inner circle of 5 countries, and then you might expand to the rest of NATO, and then you can build sort of layers of cooperation, and the quality of what you share and what you talk about varies in each of these configurations. So I don't know if you think there's any lesson from that for this international cooperation on criminal issues.
Yeah, well, Ellen, it's a really smart observation, and I guess the only caveat I would say is that in the past, intelligence cooperation has been able to go forward when, at a state-to-state level, conversation was not possible, and that has been in some instances where even where there are apparently allied states, but where their laws prohibit them from intelligence cooperation, for example, with the United States and that sort of thing. I mean, we have intelligence services find ways to work together below the radar screen that a more open conversation and collaboration might not be politically possible, right? If not legally possible. And the caveat that I would put out there is that I think in every single context, the shelf life of secrets is vanishingly small. And I think we continue to operate with the assumption that things will stay secret or below the radar screen at our peril. So I think that sort of window is not as wide as it once was, simply because I just think anything you do, you have to assume it's going to be on the front page of the Wall Street Journal, New York Times, and so that hampers that a little bit. I do think that consequences, I think what both of you are saying is that consequences are having the ability and the will to impose consequences for bad behavior is absolutely essential if you want to modify behavior and if you want to preserve institutions. I think one of our challenges has been, certainly again in the field that I know best, which is cybersecurity, but I see it across the board as well, is that we don't have a very granular toolbox typically. Right? So suspension may be your only option, and there are significant consequences to that. One of the things we ought to be thinking about is, can we build in more tools? Can we build into these institutions ways to dial a response that is perhaps more commensurate with the infraction, or that puts us in a better position with regard to the prospects for escalation, retaliation, and consequences. And I don't think we spend nearly enough time on that. And one of the classic areas that we always turn to is economic sanctions. We use sanctions a lot in these kinds of contexts. And given how much we rely on sanctions, economic sanctions, it is shocking how little time we spend thinking about, preparing for, organizing around, training, establishing doctrine, et cetera, for the use of economic sanctions. A dear friend who wrote a book back in the 90s called The Dismal Battlefield. He's a military planner in DOD who talked about how we spend all this time and effort and money doing military planning. We are unequaled in the world with regard to the degree to which we do military planning. And then in almost every conversation at the White House, the decision is made, well, we can't go with military here, so let's just adopt economic sanctions. And it's a last-minute decision, and they're imposed.
Well, it's also
Yeah.
a preference of the Hill. I think Congress prefers to go do sanctions first and tries to avoid unless there's an imminent threat. I want to open it up to the room, and please just, I think there are microphones that are going to circulate, so anybody who wants to ask a question or make a comment, you're most welcome. We've put a lot of different kinds of issues on the table here. We can return to some of the themes from earlier in the day, but welcome any comments from the floor. Anybody brave enough? Yes, we have a question here.
Susan, in your earlier remarks, you discussed the undermining of confidence in the judiciary. And I'm wondering what practical steps would you advise?
So, the project that I'm leading at the Center for Strategic and International Studies on defending democratic institutions, we've gone at this with kind of a two-pronged approach. So one is recognizing that these information operations to undermine confidence in democratic institutions are often cyber-enabled, like we saw with the hacking and leaking of emails in the run-up to the 2016 election, or like we might see, I mean, you can imagine how you might use malicious cyber activity to undermine public confidence in the competency of the judiciary by going in and altering data in courts, who should be released, who shouldn't, what was the final judgment, leaking draft opinions, all kinds of things, DDoS attacks, ransomware attacks. So one prong is we have been working very closely with the federal judiciary and state courts on improving their cybersecurity. The second is improving and strengthening public resilience and the resilience of these institutions to the propaganda piece itself. And so part of that is just raising awareness, and I've been doing a lot of speaking to try to raise awareness, to make people focus on the fact that this is not just a broad Russia attack to sow division and chaos, but that there are some very targeted things going on here, including targeting confidence in the justice system, including prosecutors as well as judges and courts. And so raising awareness. We're talking to lawyers particularly about rapid response teams that could quickly go into situations like Twin Falls, Idaho, where false allegations that Syrian refugees had raped a young girl at knife point were spread by Russian social media, and where they then tried to get people out into the streets the way they had in Berlin in the Lisa case. So that you have folks who can come out and speak quickly to tell what the truth is, to put down misinformation. And then finally, bringing the national security imperative to the growing push for greater civics education across the country. And that gets to this point that we have complacency that I think we do have about the inevitability of democracy.
Yeah, I'd like to echo that because it's not a magic bullet, but it's ultimately the fundamental defense, which is a question of education about media literacy. And I was thinking about this the other day. We kind of accept that for a lot of people, if something appears on the internet or in social media, it's accepted as true. But if you've ever stood in line at a grocery store, they have like the National Enquirer and the Globe and all these other rags, and always with outrageous headlines. And if you're waiting to get your food checked out, you might flip through them for a laugh. But I've never met anybody who believes any of that stuff. And that's because when you're little, your parents tell you this is all nonsense, and you learn that it's not to be taken seriously. And therefore, using these items to mount a propaganda campaign would be difficult. And I think we need to start to think about how do we educate folks, even from a young age, about how to look at things that appear. And to be fair, not just on social media. Some of what appears in so-called mainstream media is often exaggerated or poorly sourced, and people need to be able to evaluate that.
Yeah. I think we have time for one quick question in the back. Yes? And then.
Thank you. My name is Everett Price. I'm with the U.S. Helsinki Commission on Capitol Hill. Thank you very much to the panel for your comments today. My understanding is that U.S. engagement with Interpol is managed with an MOU between DHS and DOJ. And one criticism that I've heard at times of how Interpol operates is that, it's an organization for and by law enforcement individuals, where a lot of the functions or a lot of the decisions are ultimately political ones, not merely law enforcement ones. So I've heard recommendations of kind of including a little bit more perspective from diplomats in U.S. engagement. I know that Interpol does interface quite a bit with the State Department in its work, but whether State Department should play an even bigger role, perhaps even in the leadership of U.S. engagement with Interpol. I was wondering if you, particularly if Secretary Chertoff, given your leadership at DHS, if you have any reflections on that from your experience with U.S. engagement with Interpol.
Well, so I guess I dealt with Interpol at DOJ when I was head of the criminal division and at DHS. At DHS, at least in my time, most of the issue had to do with lost and stolen passports. It wasn't particularly politically fraught. It was about actually the mechanics of seeing if there were passports that were invalid or that had been stolen and therefore, you needed to be on the lookout for. I think at DOJ was much more based on the idea of pursuing criminal cases. In principle, I don't have a problem with the State Department being involved. Typically, in the vast majority of cases, these are pretty straightforward cases. I think there may be a category of cases where there's where the sending country is questionable, that maybe there needs to be a greater degree of involvement and at least maybe a heads up from the State Department that this has to be taken with a grain of salt. I will tell you that the red notice doesn't start the extradition. It may be that someone is stopped, but ultimately the judgment about whether there's evidence to extradite is made by the Department of Justice, and that's it's pretty rigorous. It's not based on just, the Russians say this. And so I know of a number of cases where the government simply declined. The problem with the red notices, as I understand it, is once it's declined because of a lack of evidence or a lack of quality of evidence, it doesn't stop them from being issued. And I think that it's the repetitive, how many at-bats do you get that really creates the abuse problem.
Yeah, maybe it's just me that finds this odd, but does it not strike any of you as odd that we are in favor of imposing sanctions against the Putin administration, both on the Magnitsky sanctions level, because they have identified individuals who are associated with persistent human rights violations linked to the Kremlin, and on the state-to-state level, following the expulsion of diplomats and the finding of the OPCW that Russia used chemical weapons in the Skripal attack. So there seems to be a general liberal consensus in the US and in the West that is the right response. And yet, at the same time, there's a debate about whether we should continue to act as the extension of the policing arm of that very entity. Now, bearing in mind that the Magnitsky sanctions were themselves adopted around the world, including in the US, because of a systematic abuse directed against Browder and all of the other people associated with Hermitage Capital, we heard about earlier on today, and that a part of that is, as Secretary Chertoff says, repeated applications against the same people for red notices. I mean, it does strike me as pretty strange that we end up, on the one hand, sanctioning this state for political abuse, but on the other hand, continuing through Interpol and other mechanisms to make our own law enforcement available as an extension of theirs. So that's the first point. The other point I wanted to come back to was the notion about a more granular response. I think one can be a little bit more specific than that. I think one can say, Interpol should, right now, be reversing the burden of proof in Russian cases. It should be adopting a presumption of political interference in breach of Article 3 of its constitution, simply because of the pattern that's been proved up until now. Obviously, that doesn't mean that there wouldn't be cases which could go through, but it would mean that a very much higher threshold should be required. If Interpol doesn't do that, if they can't do that, then I think one needs to be, thinking about a period of time for recalibrating the entire arrangement into a much smaller group of states that you can trust.
Well, thank you. And I think we've just ended on a note that I hope will be useful to the final panel. But I hope you'll all join me in thanking our panelists for this very interesting conversation.